Welcome back to More Law. The Bar Associations require that we put the name, address, and phone numbers of the lawyers who appear on this television program. Today, Karen Rolcik, 8859 Cincinnati Dayton Road, Suite 201, Westchester, Ohio, 45069. Her phone number is 513-777-7400. And Don and Dan Moore, 1060 Nimitzview Drive, Suite 200, Cincinnati, 45230, 232-2000. And you can also catch us on either Fox19.com or at morelaw.com. Thanks very much for joining us today. We are going to now go to Audrey from Cincinnati. Audrey?
Yes, I had called you because my father had passed away. 2 weeks later, his mother had passed away. In the newspaper in Alabama, they said that all the estate would go to his children, which was me and my two brothers. And my auntie was living then, and I haven't heard anything else about it because she passed away. I was just wondering, what should I do now?
Karen, that sounds like a situation that doesn't happen all that frequently, but from time to time you see that when you've got rapid passing of people with very short period of time in between.
Right, and as I understand, your mother-in-law passed away first, is that right?
My father passed first, and his mother died 2 weeks later.
2 weeks later. Okay, well, and she lived in Alabama?
Yes.
Well, Alabama law is going to control what happens with respect to that property, whether or not she had a will. It's going to control whether her property is going to go to your father. Oftentimes there's a requirement that a person who's going to inherit from another person has to survive by a period of time. Sometimes that's 30 days, sometimes that's 60 days. So if your father passed away prior to his mother, he may not be entitled to anything, and therefore you may not be entitled to anything. Again, it depends on how the will is written and how the state law applies if she died without a will.
She did have a will, and it was left to my dad.
And it was left to your dad?
Yes.
Well, since your father was not living at the time that she passed, you have to look at that will to see what happens in the event that he is not alive. There would probably be an alternate or contingent beneficiary designated in that will.
That can get pretty complicated, can't it, Karen? You get into per stirpes and per capita and all that stuff?
Exactly.
So if her will provided that if he passed, it would go to his issue or his children, then the lady Audrey would still take from her grandmother. And if it provided that it only went to survivors of the grandma, then it would not.
That's correct. So the key language is whether or not the will provided that he had to survive his mother, and if he didn't survive his mother, where that property would go. But it could very well go to his children.
That sounds like Audrey's going to need some advice and some help specifically on that. And Audrey, there are lots of lawyers around who practice that type of law, and I'm sure they'd be happy to help you. You're going to need the help of a lawyer, at least in Cincinnati, and perhaps in Alabama as well. Now, there was one other issue I wanted to get to quickly, and that has to do with powers of attorney. And that's something that you do on a regular basis, isn't it, Karen?
Oh, yes, and I think powers of attorney are probably some of the most important documents that people can have. There are two types of powers of attorney, one for financial matters and one for healthcare matters. Mm-hmm. The financial power of attorney is one where you designate someone to manage your affairs in the event that you're incapacitated or disabled. Sometimes people just don't want to manage their finances anymore, and so they say, you go ahead and do it, and that's fine. The healthcare power of attorney is a very important document because many people in Ohio believe that if you're married, your spouse can make routine medical decisions on your behalf. If you're not married, that your parents might be able to, or that your children might be able to do that. And that's not the case in Ohio. You need to have a written document that says who's entitled to make those routine medical decisions on your behalf in the event that you cannot make those medical decisions.
And Dan, that impacts the personal injury area of law too, doesn't it?
Yeah, it was what I was talking about at the beginning of the show. I mean, if somebody has to come and get medical records for their family member who's in the nursing home or in the hospital or something, the hospital requires these power of attorneys in order to get those medical records. And if you don't have them, then you have to go through an extraordinary step to be appointed the person's guardian, and that's more complicated and more difficult. It's easier, simple. Go to a lawyer who does this kind of thing. They can execute the power of attorney for you, and it takes care of the problem.
You know, one of the things that, that I think is very important is that people plan in advance, especially young people. We've got an awful lot of people who are in Dan's category. They've got kids, and they need to make wills to provide for their kids and what would happen, because a lot of times they think it would just go to their spouse, and it doesn't, does it?
No, it does not. And the important thing for young couples with children is to have a will, name a guardian for the children, and then make sure you know what's going to happen with the assets.
Karen, thank you so much for being here.
Thank you very much for having me.
I really appreciate it. You've done a great job. Listen, folks, we have next week we have all about health care claims. We have all about injuries the week after that, and we have Ask Us Anything after that. Don't forget to join us 9:30 Mondays, more law, and we'll look forward to seeing you then.